All rise. First District Court of Appeal is now in session. All who have business before this court draw near to attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning and welcome to the First District Court of Appeal. We have one case on the docket today, Charles Adelson versus State of Florida. Counsel, when you're ready, you may proceed.
Good morning. May it please the court, Michael Luffman on behalf of the appellant, Charlie Adelson. Seated with me at counsel table is co-counsel Laurel Cornell Niles. I'd like to reserve 5 minutes of my time for rebuttal.
So noted.
I'm hoping to focus the beginning of my time this morning on the first two claims, which are the jury selection claims, and I think they're intertwined. And then I also intend to briefly address ground three. So let me begin with the jury selection claims. Claim one concerns the trial court's failure to grant the motion for a change of venue. Claim two concerns the trial court's failure to strike the panel, and then specifically, as that issue evolved, to strike the middle group of jurors, jurors 51 through 102, for reasons that I'll get into in a second. Let me begin with the change of venue argument. The numbers in this case are pretty striking. We know that of the 130 jurors who were questioned individually, and that's the way this process went. The judge began jury selection by individually questioning jurors in groups of 50. There were 3 total groups that were ultimately questioned to determine whether or not they've formed an opinion about the case and whether or not they've been exposed to pretrial publicity. Of the 130 that were questioned, 54 said that they had formed an opinion regarding innocence or guilt, and 53 of those had formed the opinion that my client was guilty.
And they were excused for cause,
They all
correct?
were.
All right, so let's start a little bit about the procedure that the rules require before those interview questions are even asked. Why don't you address, the rule requires a written motion, an affidavit, and a good faith statement, correct?
Yes, Your Honor.
All right, and that didn't happen here.
No, Your Honor.
And what type of things would we have seen in an affidavit before any jurors were interviewed?
I don't know, and my response to that is, and I understand that I'm attacking the rule and it's a requirement, although there's certainly case law that says that if a motion in any context is made orally, and if there's a component within our criminal procedure rules that requires it to be written, if it would be a useless gesture for such a motion to be submitted in writing when it's been thoroughly discussed and ruled upon orally, then that's not required. And I think that, again, specifically applies to this type of case. We know the Florida Supreme Court has been very clear that change of venue claims almost always need to be considered during jury selection, that a judge is not going to grant a change of venue claim pre-trial.
Sure, but one of your arguments is that the Tallahassee community, almost 300,000 people, was so tainted by what you characterize as pervasive media that there could be no jury selected that would be impartial. And wouldn't affidavits have shown, for instance, that what types of media that the citizens of Tallahassee and this community were consuming? And you definitely see in the record the local sources, national sources. You make the argument that this isn't like the 1994 trial of Danny Rawling in 1994, where people would watch Dan Rather or Tom Brokaw, and I think that's right, but wouldn't the affidavits also have shown that maybe consumers curate their media differently? We saw in this transcript there were many consumers of media who said, I'll give some examples. They don't watch television. I turned off my propaganda box 3 years ago. I don't read the paper. That's for wrapping mullet. Very rarely do I watch the news. And so you see a lot of behavior in this typical kind of Tallahassee community that's different than 1994. Couldn't you have shown those things in an affidavit before you interviewed a single juror?
Clearly, the rule says that should have been done, and I'm not disputing that it should have been done, but I submit that it was established by the record as you just indicated. The record very clearly shows the way that the 130 jurors that we're talking about consumed their information about this case. And it's not just contrary to what happened in 1994, what was happening in the 90s, it's not just the print media. Clearly, the Tallahassee Democrat covered this case extensively. It's not just the local news. Clearly, the local news covered this case extensively. But unlike the 90s, now we have several jurors saying that they're getting their information from cable news networks, court TV, shows like
YouTube, Court TV, 2020, Over My Dead Body podcast, The Preston Scott Show, Tallahassee Democrat. But what you don't have in this record is how many times those exposures happened, whether they were biased or not, whether there were some broadcasts or podcasts that, in fact, argued that your client was innocent. So we don't have the content of that to show how that would have influenced the veneer, correct?
We do not have that from affidavits pretrial showing the things that you just mentioned, but we do have that in the record based on the answers that the jurors gave. And again, when we are talking about a little over 40%, that's a huge number. In the Murphy case, I believe it was right around 25%. And in that case, the court said that's not enough. Here we are at 40%. So when you talk about 40%, when you talk about the judge making a finding when granting the protective order pretrial that Tallahassee is in fact a small community, when you talk about this case has been permeating Tallahassee media sources for almost a decade at the time of this trial, when you talk about there was 3 previous prosecutions, one of which resulted in a mistrial and a subsequent trial just a year before my client's trial.
Sure, but why don't we talk about what the Florida Supreme Court says when there's pervasive media? Certainly, no one would argue that there wasn't pervasive media in the Danny Rowland case, right?
Correct.
We're talking about 5 murders, college town, again, maybe a small community as you would describe it, perhaps.
Sure.
So with that, since that case, in the Ellerby case, the Armstrong case, the court has said that it's not enough to show that media was pervasive. It was, could the juror be impartial? Every single juror seated in this case said that no matter what contact, many of them had no contact with media or information, that they could be impartial. Isn't that right?
That's correct.
All right, so specifically, I'd like you to address the Armstrong case. The state raised it in the answer brief, and you did not address it in your reply brief. The Armstrong case, the Florida Supreme Court, and this is 24 years after the Manning case that you cited in your case, they said that if you don't renew your objection to the jury before the jury is impaneled, in fact, your client accepted this jury, that you have waived it and we may not reach that issue. What do we do with Armstrong?
So two responses to that, 3 actually. Just quickly regarding my client accepting it, I don't know that my client accepting it matters much. I think the concern is, did defense counsel renew the objection? The state made an issue out of that, and if you look at the question asked of my client at the conclusion of jury selection, the judge literally says, you have no choice but to accept because you have no strikes left.
But was
do
there
you
an
accept?
objection?
No,
Was there an
I
objection?
understand, but again, so that I'm just responding to the concern. I understand the state raised it, and that's probably why you're saying it, but my client accepting the jury is irrelevant to this matter. The question is, did defense counsel renew the objection? I acknowledge that generally is what's required for any type of jury selection claim. However, Manning is specifically a case where we know from the dissenting opinion the request to change venue was not renewed.
But I'm going to repeat, Manning was decided 24 years before Armstrong in 2003, where the Supreme Court specifically said the failure to renew is waiver of the claim.
I understand.
That's precedent that's binding on this court, is it not?
The court doesn't, we're all familiar with the principle that a court doesn't overrule itself sub silentio. The court has not specifically said Manning's no longer good law. That being said, I rely upon Manning because it was ultimately reached consistent with what I think the U.S. Supreme Court has said is an appellate court's burden to go through the record in one of these cases to determine if there's a change of venue issue. But beyond that, I will acknowledge that at the very least, to the extent that this court finds that it's not preserved because it was not renewed, then the question is it fundamental error? And I submit that based on the facts of this case, we do meet the fundamental error standard. In the Smith case just 4 years ago, the Florida Supreme Court specifically said that the failure to preserve a change of venue claim can nevertheless be reviewed under the fundamental
Well, my
error
understanding is, the reason we have this very, very unusual requirement for, a renewal of an objection is not just simply, it's not just Simon says, just, you got to do it twice or else. It's that it is possible that the defense is happy with the jury. It's generally in the challenge context when you challenge a juror and they want to see whether you renew that challenge, that you are in fact satisfied with the jury. So I don't know if you can say that it's a fundamental error issue if, in fact, the defense was satisfied with the issue. Now, I did believe when I saw Armstrong, it's like, wait a minute, it's not what happened in Joyner. It's not a cause challenge. It's change of venue.
Correct.
But when you read Armstrong, it's very clear. First of all, it says that a change of venue motion is premature until you actually attempt to select a jury. What
Correct.
that says to me is a change of venue is a jury selection issue.
Sure.
And what I draw from that is that, just as Judge Rowe is saying, if you in fact are able to find jurors who swear that they are untainted, then I don't know if there is in fact a change of jury issue. It very well may be that the defense thinks, okay, I found untainted jurors, I don't really have any reason to continue with the change of venue objection. So that raises two things. Number one, whether the fact that you have untainted jurors overcomes the fact that the community may have had a low level of taint. And number two, the suggestion that it's fundamental error when the whole point of the objection is that the defendant is satisfied, which I don't think a fundamental error claim can overcome.
So a couple of responses to that. Again, the Smith case is 2021, and it's specifically page 28 of the Florida Supreme Court's opinion, and they clearly went on to address the claim for the change of venue motion, despite the fact that it was not preserved, and they did so under the fundamental error standard. And so, I'll quote from the case.
But isn't there a difference between preservation and waiver?
Sure, well, yes, but, so if we're going to waiver, and now if you're addressing what my client said at the conclusion of jury selection, that's no waiver on my client's part when the judge specifically told him, you have no choice.
I guess perhaps I should just read Armstrong again, because Armstrong says a motion for change of venue should be renewed at the conclusion of jury selection or be considered waived. So it is the failure to object that is the waiver in this context. I mean, do you read it any differently than I do?
If that were the case, then Smith in 2021 would be wrong. And Smith obviously is more current and specifically says that because the issue was not preserved, because it was not renewed at the conclusion of the jury selection proceeding, we review this claim for fundamental error. So I submit to you, again, this court has the ability to review the claim. Smith from the Florida Supreme Court very recently has said, for at least a change of venue claim. It may be different for a peremptory challenge, the failure to grant a cause challenge, but when it comes to change of venue, the Florida Supreme Court has specifically said it can be reviewed for fundamental error. And I guess going back to Manning, and I understand the time difference, but Manning would be a great example of that. You literally have the attorney in Manning saying, at the conclusion of jury selection, I believe we picked a fair and impartial jury. And I submit that there's no jurist in this state that would review the facts and reach a conclusion, unlike what the Florida Supreme Court did, that there's no way that venue could have been fair within Columbia County in that case. So that's exactly why these claims can still be reviewed for fundamental error.
Just generally speaking, you know, normally when we talk fundamental error, it's because that an error wasn't preserved below. Can
Correct.
fundamental error be affirmatively waived?
If defense counsel had said, if the question rather than to Mr. Adelson, do you accept this jury, and let me point out you have no choice but to accept the jury, but answer me anyways, do you accept this jury? If it had been defense counsel, you previously raised some objections. Do you now no longer renew those objections and accept this jury? If that would be the case, I would have no ability to make an argument in front of you today. That would be waiver. That's not at all what we have in this record. I think the
Well,
fact.
it sounds to me like you're going up a 3850 avenue, but let me ask you this question. Is Armstrong's a 3850 appeal?
Correct.
The other cases we're talking about earlier were direct appeals. Is
Correct.
that distinguishable?
Perhaps. I mean, again, a lot of times when the Florida Supreme Court considers 3850s, they also consider 9.141s in the context of failure to raise issues on direct appeal, and that's also the way, in Hilton at least, that the ways these claims are being raised. But again, in a direct appeal claim, on a direct appeal, the issue is it preserved? If it's not, can it be reviewed for fundamental error? I submit that there are some things that cannot be. Generally speaking, the failure to renew a cause challenge is not something that's going to be reviewed for fundamental error. The court's been clear about that. And if there is a specific waiver on the record, we don't have that here, then no, you wouldn't be able to review it for fundamental error. Waiver trumps fundamental error. We don't have a waiver here, and I submit that fundamental error is still the standard.
But surely you're not arguing that now a trial judge has to, who's represented, a defendant's represented, now a trial judge has to look to the defendant, who's represented by counsel, to say, do you individually accept a jury?
I have no idea why the judge did that in this case. But
But are you promoting a bifurcated question by a trial judge to counsel and a defendant?
I think in the context that the judge is asking the question in this case is, it fairly could be construed as, do you have any other strikes? And that's why, and every time that question was being asked, there was a strike, because there were back strikes in this case. So ultimately, when he just asked the same question he'd been asking up until that point, the question was, do you accept this jury, i.e., do you have any other strikes? And I guess let me throw out there, you have no other strikes, so you have no choice but to accept the jury. That's why it's being said here. Again, I acknowledge it's incumbent upon defense counsel to jump in and specifically say, we renew the objection, but if that's not done, it's still reviewed for fundamental error. I see that I'm getting my rebuttal time. I would like to make a couple other quick points about the merits.
I'm going to extend your time by 5 minutes. I'll
Thank you.
do the same thing for the state.
Thank you, I appreciate that. I do need to address, so we have, and I've already talked about this, the almost 40, or a little more than 40%. We have the Tallahassee community, we have the different ways that social media infects jurors in a community now, but we have more than that in this case. In Patton, the U.S. Supreme Court said exactly this: adverse pretrial publicity can create such a presumption of prejudice in the community that the jurors' claims that they can be impartial should not be believed. The U.S. Supreme Court is saying that
And they're saying that, and they probably are saying that on a record where there was a record that the media exposure was indeed adverse.
Well,
And again, we can't presume that,
Let me
can we?
let me go further with that, Your Honor. What they're saying is there could be such intense media influence in a case that we may not even believe what the jurors are saying. And if I came to you with no evidence in the record and said, that's what we have here, you would say, Mr. Rufferman, you're speculating. We have 2 instances where jurors lied directly to the trial court, asked
So
point
are we
blank.
supposed to just assess the credibility of these jurors? Is that what an appellate court is to do under this theory?
No, but what we have in this record is 2 instances where jurors were specifically asked, have you formed an opinion about guilt in this case, or have you posted anything on social media about this case? In both instances, the jurors said no. In one case, thanks to good defense counsel, good lawyering, they had a couple of posts from that juror and presented them to the trial court where that juror had said that the parents of Professor Markel should assist in killing Mr. Garcia, and then went further when my client was charged and said, surprise, surprise, Mr. Adelson is charged. But the worst one is by far the next one. Mr. T is how I refer to him, as the first initial of his last name. Mr. T stood in front of the trial court and when asked, have you formed an opinion about whether or not this defendant is guilty? He point blank told the court no. Lo and behold, 2 jurors later, Miss M comes in and by happenstance is asked the question, has anyone been discussing this case amongst the jurors? Oh, why, yes. In fact, that gentleman that was just excused with the glasses, what's he been saying? He's been going around telling other jurors that Mr. Adelson is guilty.
And both of those jurors were excused for cause, were they not?
Yes, but statistically, if those 2, it's very hard to prove someone's lying. Usually you rely upon some luck or some good lawyering with coming up with the post. So we know that one juror reported the other juror, and that's how we know that juror was lying.
And then being careful, defense counsel was offered the opportunity to review the tapes of the jury assembly room to see what comments were made, what are the reactions of the other jury members, and defense counsel said, no, I don't want to see it.
But here's the problem with that, and going to the second claim now. The second claim is a very specific, easy fix. We know for the second group of 50 jurors, 51 through 102, problems were happening. We know about halfway through jury selection, it's reported, number 1, that jurors have not followed the judge's direction, so much so that the judge, when he heard about this after 2 of the jurors reporting that the jurors have been talking about the case, goes out and admonishes those jurors pretty sternly, do not talk about this case. But we also know...
But the problem is the content of those communications. And they were like this: high-profile case, it's the Charlie Adelson case, it's the Dan Markel case. Which of the... And that he's guilty... But again, the trial court offered your client the opportunity, the defense counsel, go listen to the recordings in the assembly room and you can bring back some statements that would in fact taint the jury. How did these statements taint the jury?
We have 4 statements, right?
Right.
So we have one where a juror said, we've been talking about it all day, is literally the quote. We have another where there's some pretty...
Talking about it, I mean, content. Let's get to the content.
Talking about the case all day.
Again, but that you could have questioned those jurors to get specific information on what content tainted the jury.
Okay, that's one juror. A second juror then said that there had been a lot of talk about he's a professor at the law school and revealing a lot of the facts about the case. There was a divorce going on between the professor and the wife, but the two that are far the most concerning are the 2 jurors that specifically went back, a male and a female, the one with the glasses and then an older female that went back and told the other jurors he's guilty. In fact, if you look at juror C, on page 2581, you have, coincidentally, when she's asked, after she reports that she's heard that this female juror is saying that he's guilty, oh, what's your opinion? I think he's guilty too. This is influencing the entire, that set of the panel. So I... Let me come back to why I think this was an easy fix. There was 3 groups of 50. It was clear 8 of the jurors that sat on the jury came from this middle group, 51 to 102. At the midway point, the judge admonished the jurors to no longer talk about the case again, and the judge said from this point forward, every juror, we should ask them, have you been discussing the case? Of those 8 jurors that came from the middle group, 4 preceded those 2 things. So for those 4 jurors, we have no, and I can quickly tell you the page numbers regarding those. I have the names, I apologize. I will say them. It's Brazos, 2467. It's Kraft, 2497. Milne, 2514. Hawley, 2528. Those 4 jurors were all exposed to...
somebody saying, I think that the defendant is guilty.
Yes, multiple
So-
times.
Okay, so they rendered that, so you have jurors who probably shouldn't be serving and didn't serve, is my understanding.
How many other were influenced by
Expressing
that?
their opinion that the person was guilty, but don't we typically, we're going to strike a panel, we'll require the striking of a panel when facts come in that would otherwise not be admissible. Isn't that the typical standard for striking a veneer?
Strike 50 jurors, just those 50. The clerk actually
That's fine,
said,
but the reason for it isn't that somebody has rendered an opinion as to the guilt of the defendant, it's whether they've been exposed to facts about the case that would otherwise have been inadmissible.
oh, I don't agree with that, Your Honor. Jurors constantly saying, when they've been told not to talk about the case, talking about the case and saying he's guilty, and being exposed to that, when you already have all of the social media presence that's involved in this case, that's improper. And again, the fix was easy. When they weren't sure in the 3rd group of 50 whether or not they were going to finish, the clerk said, we have another group of 50 downstairs. How easy would it have been for the judge to say, wow, I mean, he was bad, you could tell. I'm frustrated. They're not following my directions. They're lying.
Couldn't we have sidestepped some of the speculation if the tape of the jury assembly room had been reviewed and then some content specifics argued?
I think it's clear that this 50 was tainted. And if you go back to the Manning case, what the Florida Supreme Court said that every reasonable step should be taken to preserve a defendant's trial by an impartial jury. And to this end, if there is a reasonable basis shown, the court should take action. There's, without question, a reasonable basis. We have one juror that said, living in Tallahassee, you'd have to be under a rock to know about this case. Another juror said, the impact that this had on me, when you hear about this, it sticks with you. We have so much about this case, but then when you boil it down to that middle 50, and we know that there's not 1, not 2, 4 different jurors that has disclosed that they've been talking about the case, and it's getting the judge frustrated. He has to re-admonish them, but he doesn't go back and question the ones that have already been questioned about whether or not they've heard discussions from other jurors, and 4 of those jurors who were never questioned ultimately sat on this jury. That's a reasonable basis for the judge to have taken the easy step. You're right, at this point I'm frustrated. They're not following my instructions. 51 through 102, they're done. Let's bring up the next 50. I will be very clear going forward. He was. And if we need to go to the 4th 50, we will. That's what should have been done, and because of that, my client didn't get a fair trial. I'll reserve my last minute for rebuttal. Thank you.
And I will extend you an additional 3 minutes, and the same for the state, so you'll have a total of 8 extra minutes.
Thank you, Your Honor.
May it please the court. My name is Charlie Lee. I work for the Attorney General's office, and I represent the state of Florida in this case. I'd like to start out with the questions that judges here have asked today. One thing I do want to clear up is the preservation issue that Mr. Adelson claims in Manning in his reply brief. He talks about that in that case, the attorney below never filed a written motion, didn't renew his objection to the jury or anything like that. Those facts come from the dissent in Manning. The three justices of the Florida Supreme Court who felt that Manning should not have his conviction overturned, who felt he did get a fair trial, noted that his attorney affirmatively accepted the jury. Now, from Manning, we've come to Armstrong. And Armstrong is backed up by all the cases where we have Batson challenges. If someone files a Batson challenge saying they didn't have a fair jury because of the demographic makeup of their jury, if they affirmatively accept that jury, then they've affirmatively waived that objection. They have to do it once again. They cannot accept the jury like Mr. Adelson did twice to his jury and to the alternate jurors.
But isn't really, change of venue is not the same as failure to renew specific challenges to specific jurors. It is a much broader, as Mr. Ufferman was talking about. It has to do with what was known by the community. It's whether the community is one that cannot hear the case. It's not necessarily about individual jurors. So why should we apply this rule that, I understand what Armstrong says, but I've also read Joyner, and I know that that's where the Supreme Court first made this rule very, very clear, and they made it in the context of challenges to particular jurors. Why should we apply it? Forget what Armstrong says. Why should we apply it?
You should apply it because it is about individual jurors. Because Mr. Adelson, he's entitled to an impartial jury. He's not entitled to an impartial community or city or world. There are people out there who are going to prejudge Mr. Adelson's case. There's people out there that will prejudge every case. In every jury selection, there will be jurors on the panel that will say that they believe the defendant's guilty just because he's sitting in the defendant's seat. That happened in Mr. Adelson's case. It'll happen in every case that's tried this week at the Leon County Courthouse. It has to do with the actual jurors. One of the things that Mr. Adelson brings up in his reply brief is structural error, and I'm going to explain why this isn't structural error, although Mr. Adelson has waived that because he didn't bring it up in his initial brief. But let's look at the 12 actual jurors that served on Mr. Adelson's jury. Adelson accepted all 12 jurors during the pre-screening phase. All 12 said that they would be fair and impartial. Mr. Adelson gives us no reason to believe them. As Judge Thomas pointed out, there's not a clear record here of why we shouldn't believe them. And Judge Rowe pointed out, because affidavits weren't filed in this case, we don't know what the pretrial publicity is. This isn't like Shepard v. Maxwell. This isn't like Irvin v. Dodd, where, you know, Mad Dog Irvin was in the press, his serial killer in the press all the time. It's not like those cases. We don't know because Mr. Adelson didn't file a legally sufficient motion.
But he did show that of the 54 prospective jurors who had a considerable amount of media exposure, that 53 of them found that Mr. Adelson was guilty and said that they couldn't be impartial. Now, there's much of jurors might be lying about whether they had the exposure. Is it also possible that jurors were lying that they couldn't be impartial and absolutely thought he was guilty to get out of jury service? I mean, I think there's a lot of speculation going on here that we really can't get to.
Well, that's where I point to Singer, a case that Mr. Adelson relies upon. And in that case, and this is a 1959 Florida Supreme Court case, they said that the Florida Supreme Court said they had some doubt as to the impartiality of a fairly large number of the veneer men, which might be indicative of the inhabitants generally of the community. But we cannot determine error on doubt. That's the Florida Supreme Court in Singer.
So would it have been different, for instance, if Mr. Adelson had brought forward evidence that there were 100 broadcasts on the Preston Scott Show, that there were 200 pieces by WCTV, 300 articles in the Democrat, 50 podcasts and court TV programs, and that all of the speakers in those programs, or some high percentage of them, pointed to guilt for Mr. Adelson? Would that be different?
It might be different. All we have is secondhand knowledge of the jurors that were there. That's all we have. It might be different. We have, I think the court TV host is the only one that we know expressed a negative opinion.
And even the jurors who were interviewed about their exposure to the media sources I just listed, some of them found that those sources were credible, and some of them found that they weren't credible. They called into doubt whether the person who was on one of the news programs was partial or not, right?
Correct, Your Honor. And as to Mr. Adelson's numbers, I disagree. I noted, he quotes 29 jurors in his initial brief. I noted 22 that said they couldn't be fair and impartial. But even saying it's 40%, which I believe is what he's arguing today, that's a far cry from Irvin, where it was 2/3 of the jurors had extreme bias against Mr. Irvin. I mean, he was a serial killer that in the press, I believe several states had, sheriffs had said that they were going to make sure that he died, was executed. One of the cases, Murphy, and I do agree with Mr. Adelson, there are some similarities between issue 1 and 2. And moving on to issue 2, we have to give jurors credit. Just because this young man said that Mr. Adelson was guilty, and another man may have forgotten what he posted on Facebook about Mr. Garcia, that doesn't mean that the entire jury pool was tainted. As Judge Thomas pointed out, the defense counsel was given an opportunity to go back and review video of the courtroom or the jury assembly room wherever this happened. They were moved from the jury assembly room to courtroom 3G, and the defense declined. So we don't know, there's no indication that this young man stood up on a chair and yelled this out at the jury pool in general, or whispered it to someone. We don't know. As far as the gentleman with the Facebook page, we don't know exactly what he posted about Mr. Adelson, other than he said something about surprise, surprise. And the defense counsel didn't establish a record. And again, going back to Singer, we're not going to reverse this case based on doubt. This isn't a case, because this is not a structural error. And neither the U.S. Supreme Court nor the Florida Supreme Court has ever held that a failure to change a venue, or denial of a change of venue motion, or prejudice within the community, or bias amongst prospective jurors has ever resulted in structural error or per se reversible error.
Didn't the Manning court, though, suggest that a venue error is a structural error?
I don't think so, Your Honor, because they looked into, the majority in that case looked into the individual facts, case by case. When we get to Rawling, there, and McCaskill, there the courts, and it came long after Manning, they've developed a test to find out. And this is why, in this case, we had 2 voir dires. We had the pre-screening process, and then the actual voir dire, which is, far more than the average defendant gets. And that's so we can suss out and we can identify prejudice amongst those jurors, because no court has ever held that, bias amongst jurors in the jury pool would result in a structural error, because that doesn't affect the framework. Now, if there was something inherently wrong with the voir dire process, perhaps. Now, no court's held that either. But in this case, there was no problem in the voir dire court. The judge here went above and beyond by having the pre-screening process, then the voir dire, where counsel will get an extra chance to challenge jurors. One of the things in this case is the defense counsel didn't ask for any extra peremptories. He didn't even use all 10 of his peremptories until the very end of the voir dire process, which is a factor in Manning. And it's why we have those factors, is because with structural errors, those are errors that are so, such as a right to an impartial judge. It's not like we can question a judge or the right to, a defendant's right to represent themselves. We can't question a defendant about why he wants to do that. Or a public trial. If there's no public trial, we don't know what happened. We can't peer in, we can't look behind the veil and see what that error might have caused. But in this case, it's perfectly clear. Mr. Adelson agreed to 58 jurors. The jurors that served on his jury, only one of them heard another juror talking. 3 of them had no prior exposure to the case. And and all of these jurors, Mr. Adelson agreed to.
Could you address, the preservation issue aside, let's go to, can you address Mr. Ufferman's fundamental error argument?
I don't think that he can show fundamental error because he can't show that in any other venue that Mr. Adelson would receive a fair trial. This case, in modern cases often, fair trial, a different trial, a different result. Fundamental error requires the defendant to show that a different result, but for the lack of change of venue, that his case would have ended up differently. Well, that's not the case here. There's been no demonstration of that.
So it's not just fundamental error that he didn't get a fair jury. Wouldn't that be fundamental error in and of itself, regardless of what the outcome of the trial was?
Well, if he could show that he didn't get a fair jury, but he certainly did.
Well, that's his claim.
Well, it's his claim, but he hasn't shown any evidence of it. He hasn't shown why this particular jury, these 12 jurors, were so biased that, that the outside influence on these jurors would have changed their verdict. He's made no showing of that whatsoever. He didn't try to poll them. I mean, they polled them after the trial, but he didn't try to question the jurors or anything like that. There was a motion later, but there's no evidence in the record that these jurors were influenced. Like I said, 3 of them had never even heard about the case. So there's no evidence in the record whatsoever that his actual jury, because he has a right just to an impartial jury, that they were influenced by the media and the local, the conversations around Tallahassee influenced their verdict. There's nothing in the record.
I think his argument is that the media saturation implicitly biased the jurors, I think is one argument. Maybe another argument is that they are lying. They were lying when they said that they could be impartial. And he's pointing to the 2 jurors who did in fact lie. And then again, he points to the 53 of the 54 jurors who were excused for cause because they had consumed the media and felt that they could not be impartial in this case. So that's the evidence he's pointing to. What do we do with that?
Well, Mr. Adelson is asking this court to presume prejudice there, which is something that this court could only do under a structural error argument, which he's waived, and no court has ever held that it's a structural error. This court should not presume error, and Mr. Adelson has not proven any error. He hasn't proven by not filing a legally sufficient motion with affidavits that show what the media coverage was. We had that in Foster. In Foster, the defendant there filed news clips, articles that were far more negative against Mr. Foster than anything that we heard. All we have is secondhand accounts from other jurors or prospective jurors about what the media, publicity was. But assuming what they said was true, what happened in Foster was far worse, and what happened in Rawling was far more extensive. And this court, there's no reason this court should presume prejudice, and if there's no reason this court should find prejudice if Mr. Adelson hasn't proven it, and he has not.
Well, Mr. Adelson argued in the brief, or counsel argued in the brief, again, that the media environment in the Rawling case in 1994 is substantially different than it was when Mr. Adelson's case went to trial. What do we do with that?
I don't think that's necessarily true. We don't know much about Mr. Adelson, the media coverage around Mr. Adelson, but in this day and age, no media is really local. And in this case, there was over the My Dead Body podcast, there was national news. People were following this all over the country and all over the world. The environment hasn't really changed. Really, the important thing is local sentiment. if it's something that shocked the community. This is as bad as Dan Markel's murder was. 30 people on the jury, prospective jurors, had never heard of the case. In a town like Tallahassee, where people are coming and going quite a bit, it's even less than, in Gainesville, sort of the same situation with Rawling, but in Foster, that murder there with the extremely negative publicity didn't warrant a change of venue, and Foster was after Rawling. So I don't know that, I understand Mr. Adelson's arguments at times have changed, but I don't think people have. It's when we do go to pick a jury, we ask jurors, in that community, can they be fair? What have they heard? Can they set these things aside? Because after all, that is a standard in McCaskill, not whether they've been exposed, but whether they can set aside that exposure.
Does it, as long as we're talking about distinguishing the Rawling case, does it matter that we have a notorious murder and we have a lot of media from it? In the Rawling case, we had a literal serial killer on the loose, killing people. I don't think anybody in Tallahassee believed that somebody was going to pay Garcia and Rivera to come up to Tallahassee and kill them. That was not an irrational belief in Gainesville when there was somebody who literally was brutally killing people day after day for a while. That has nothing to do with the media coverage. That has nothing to do with what was happening in 1994 when he was being tried. But does it have anything to do with the decision of whether to change venue when you have something well beyond the media in assessing how the community may have felt?
I agree, Your Honor. In Rawling, the Associated Press described him as the next Ted Bundy, basically. And there is that fear and that shock. And I don't want to downplay Professor Markel's death. It was shocking. It was terribly sad. But you're right. It was certainly figured out that this was a murder for hire. And by the time that Mr. Adelson went to trial, this court had already affirmed Garcia's conviction. This was a murder for hire plot. The people in the community were not at danger as they would have been with Rawling or Bundy or even Foster with these Lords of Chaos group. I agree with you, Your Honor, that when that fear stays in a community, that can certainly poison their minds. But in this case, that fear that would have been there in Rawling and Gainesville in the 90s would not apply to Mr. Adelson's case. And like I said, it's not surprising that only 22 jurors said that they could not set this out of their mind. I know
Isn't there a difference here, though? I mean, unlike the Rawling case, there's been, now 12 years of sustained media coverage. There have now been 5 convictions in this case, and at the time of the trial, there had been 3 prior to Mr. Adelson. Doesn't that make a difference? I
think it can work both ways. I think the saturation and the fact that this case has been going on for so long may dull the senses of people. They hear about it, they get disinterested the more they hear. I mean, but I think one of the factors in Rawling is the time of the publicity and the trial itself. In Mr. Adelson's case, the crime was far removed. 9 years, as one of the jurors pointed out, prospective jurors pointed out. But the nature of the coverage matters a lot, too, and the nature in relation to the time of the trial. And there's nothing in the record to indicate that there was negative publicity about Mr. Adelson around the time of his trial that would influence the jurors to reach a guilty verdict instead of an innocent, or instead of acquitting him.
And again, that's perhaps where an affidavit may have come in and to help the defense in terms of how many media stories there were within the relevant period, the content of those stories. Again, we don't have that in the record. We just have sporadic references in the record where jurors were reporting that they had seen some media at some time.
I'd argue it's why the rule exists. It's why the rule requires
as long as we're talking about
affidavits.
the rule, counsel, I noticed, Armstrong talks about how a change of venue motion is premature until there's been an actual attempt to impanel a jury. I understand what they're getting at, just on its face, but I'm having trouble understanding how that requirement it plays into the requirement that there be a written motion for change of venue. Do you try to, do you attempt to impanel a jury, and then when you can't, you say, hold on, Your Honor, give me a few minutes so I can write out a motion for change of venue, because the rule requires it to be in writing? In other words, is the requirement to be in writing unrealistic, given the separate requirement that a motion is premature until you attempt to impanel a jury?
No, Your Honor, the rule is not unrealistic because it requires the defendant to make the initial record that he needs to make. And that is, if you file it before, if the defendant files the motion before trial and has the affidavits, which he should, like some of these cases, they went around town doing polls. And in Foster, they got the news coverage and everything before the trial. So it incentivizes a defendant to go out, get the information, poll the community, make the record for their motion, file the motion ahead of time. The court's under advisement that this is an issue, which in this case it was an issue even before jury selection. The court then, the judge in this case, then wisely took the effort to have a pre-screening process and a voir dire. And so the rule is not unrealistic. Now, the Florida Supreme Court says that we have to go ahead and try to pick a jury anyway to see if we can determine whether there is, a bias within the community that can't be overcome, but we have to test that. That's one of the reasons I'm arguing it cannot be a structural error, because this is something we can palpably test. And so that's why I believe it's not, the rule makes a lot of sense that it requires a pretrial motion with the affidavits. To conclude, I'll move on to issue 3 briefly. I think in this case, one of the things I want to argue about the evidentiary issues is Mr. Adelson's, when he brought his text messages to the court, he never took the opportunity to untangle them for the trial judge. And the trial judge should not have been required to do that for Mr. Adelson. And that's why I'm arguing it's not just unpreserved, it's an invited error, because when the trial judge asked Mr. Adelson, if you can get some texts for me that are relevant, that would show what you're trying to prove, he just said all of them.
But that is their argument. Their argument is all of them should have been admitted, not 1 or 2 that the judge might find relevant, but all of them. How can you waive that argument simply by refusing to cherry pick ones? Because
the only relevant arguments would have been if there were any relevant. I argue that even these weren't relevant. But the conversations between Meg Benoit and Donna Adelson and Wendy Adelson, he didn't separate those out and offer those to the court and say, these are the relevant text messages, and this is why they're relevant. He should have done that. The judge was under no obligation to untangle those for Mr. Adelson.
And I think there was concern about the content of the message. I think you characterized the messages in your brief as racist, misogynist, and sexist. And I can imagine that had those been admitted, Mr. Efferman might be right up here arguing unfair prejudice against his client because of this bad character evidence.
Correct, Your Honor. The judge has to act as the gatekeeper of evidence in every case, and in this case, we may have very well had an ineffective assistance of counsel in the face of the record argument had the judge not asked pointed these things out to Mr. Adelson and asked him. Is it
really the judge's job to protect the defendant from himself, though? I mean, if counsel believed that the strategy included admitting these text messages that might otherwise be viewed as negative to them, isn't that really a strategic call on counsel's part?
If it's a strategic call that no reasonable attorney would take, I think a judge does have to step in. A judge will have to step in even under a 403 analysis, if something's more prejudicial than probative. In this case, those texts were certainly more prejudicial than probative. Yes, a judge should step in.
Even if it's prejudicial to the offering party?
Yes,
now,
sir.
I'm not going to allow you. I think that would harm yourself if you admitted that, so I'm not going to allow that evidence in. I don't think I've ever seen that.
I think in the interest of not vitiating the entire trial, a trial judge should do that, and because otherwise, he's letting the defendant walk himself into a mistrial, and a judge should not be, judge should not allow that to happen or be forced to allow that to happen. Based on those arguments, Your Honors, I would ask this court to affirm Mr. Adelson's conviction for his part in the murder of Daniel Markel.
May it please the court. I'll begin by briefly addressing Claim 3. Here's why it was so prejudicial to my client to not get in the other text messages that the state was pointing to and suggesting that they had to have been about nefarious things as opposed to routine things. The text messages that have been proffered, they clearly are routine things. This is what the prosecutor argued in closing, page 2082. Quote, but as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about murder or if these call flurries around key events are just coincidence? A conspiracy can be shaped like blah, 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 and she goes on. Without knowing the content, the state objected to the jury being able to see all of the content. And now they seize upon that in closing argument and
Well,
say,
I'll ask you the same question I asked the state. I mean, if these messages, which were labeled as racist, misogynist, and sexist, had been entered against Mr. Adelson, wouldn't you be arguing here that the jury was prejudiced against him in terms of this bad character evidence?
absolutely not. Number one, that would be the actual definition of invited error. Number two, my client would be, I'm sure it's not great, but he can take the label of being racist, misogynist, whatever else. He doesn't want to take the label of being murderer. And these texts would have helped him show that what the state was arguing is not true, so much so that the state seized upon it. He doesn't need protection from himself, as Judge Winokur's already indicated. He has a right to put on evidence that he thinks is relevant. Mateo says any evidence that could be in any way, even in a slight way, relevant to the theory of defense, a judge errs in not allowing it in. The purpose of putting these texts in is not, as the trial court was saying, do they go to motive or do they go to any element of the crime? No, they go to showing that these are routine communications, not what the state is asserting. And he was prevented from putting that in, and the state seized upon it in closing.
Was this, if there was error, is it not harmless? He was allowed to testify about these texts on the stand.
Wow, my client was out on an island in this case. There's no question that it was, one other witness was presented. My client's testimony. Is there anything to back up my client's credibility? This would have been something that the jury could have looked at and said, wow, Mr. Adelson saying that he didn't do this, he didn't hire these people, he's the one actually being extorted. But there's nothing that supports that other than his testimony. This would have been, wow, look at the text messages, see them for yourselves, ladies and gentlemen.
How was your client on an island? I mean, certainly he could have brought forward the mechanic he was having the conversations with and all of the other people to testify about the kind of communications they had with your client.
You all know very well that I think defense counsel was ineffective and had a conflict of interest. I'll raise that at another date should I need to.
But it's clear that your client was not on an island, that there could have been evidence presented that would have corroborated what was in the text messages.
I agree, and the judge prevented it.
Right.
That's the whole reason for Claim 3.
Counsel, I want to go back to something that we talked about at your initial argument about what needs to be shown to strike the entire panel. Now, I did look and I saw that this wasn't cited in any of the briefs, but I'm going to say it anyway. It's Morris, Florida Supreme Court from 2017, and the quote is, for the statement of one veneer member to taint the panel, the veneer member must mention facts that would not otherwise be presented to the jury. So is that the correct standard to be used in striking an entire
I
panel?
think that's one aspect of it, and I acknowledge that's not met in this case. Clearly, the facts that were discussed did come out during the trial. I think the bigger issue is the expression of guilt. So I think the case that's closest on point is Brower, cited by the state. And Brower, the comment that was being made by a particular juror was they should just hang him. And this is what the 4th DCA went on to say. This is on page 1027 of the opinion. The offending members of the veneer were facing a 3-week murder trial and were enduring a tedious and lengthy jury selection process. They certainly used poor taste and worse judgment. However, there is nothing in the record to indicate that the offensive remarks were offered were taken seriously. The Fourth DCA's finding that the comment, he should just hang himself, was literally a joke, not an expression of the defendant's guilt. That's not at all what we have in this case. I see them into over my rebuttal time. I would ask this court to reverse, and I would end with this. If there was ever a case for a change of venue, these facts are that case. Thank
Counsel,
you.
my colleague has a question,
Oh, of
so
course.
I'm going to extend your time for her to ask it and you to answer it.
Thank you.
And appropriate, your last sentence said on the facts of this case, and that's what bothers me, and I would like a response from you. The fundamental error argument. In this case, on this record, we're arguing speculation. If you're arguing fundamental error, and you're asserting speculation of prejudice by the jury, in practical application, you're lowering a fundamental error standard below even abuse of discretion to me. So, on this record, your argument on fundamental error to me, I guess, help me understand what more than speculation is backing up your fundamental error argument.
Yes, Your Honor, and it would be, and I know they've been mentioned, but I will go and I have them written down right here. 40% of the jurors had formed, of the 130, belief that my client was guilty. Only one had not, or thought that my client was innocent. 3 prior cases, as has been discussed, and one of those cases was 2 trials, one of which occurred a year before. 10 years, almost a decade, this case has been going on in this, as the judge said, small community. 2 jurors lied. So it's not just speculation. If I was suggesting that, based on this, we can suspect that some jurors are not willing to tell the truth and really tell the court that they've already formed an opinion. We know 2 jurors lied. One of those, well, both of them lied and specifically had an opinion about the case. And ultimately, the jurors directly violated the court's order and talked about the case even though the court specifically said don't do it. When you consider all of those factors in their totality, we establish fundamental error in this case. Thank you.
Thank you, counsel. Thank you both. This court is adjourned.
All rise.